amazing think tank.
Okay, let's start our webinar. First of all, good morning, good afternoon, and good evening to everyone. Today, we have really essential names with us to discuss modernization of the Energy Charter Treaty. On behalf of EDAC, I would like to thank you to all who participate to our event today. First of all, I would like to start with the bad news. It is profound sadness to announce the passing away of Dr. Minas Kachadurian, one of the international board members of EDAC. May his soul rest in peace. Now I can continue by introducing our panelists today. We have really essential names who are the experts of Energy Charter Treaty, and what we are going to try to do is just analyze everything regarding the modernization process in the limited time. So today we have Anya. She has a diverse international background ranging from representing oil and gas companies in environmental disputes. And also she is one of the co-founders of the Climate Change Council. At the same time, she serves on the board of the non-profit organization called Swedish Association for Responsible Consumption. And we have David Collins with us. He is one of the professors at the University of London, and he is giving economic law classes. At the same time, he is a solicitor of England and Wales. And we have Mats Andernas with us today. He is a senior and distinguished academic. He was director of British Institute of International and Comparative Law, and he's a member of Executive Council of the International Law Association. Today also we have Mehmet Öğütçü, who is the CEO of Global Resources Partnership UK, and also he is the executive chair of the Bosphorus Energy Club and the London Energy Club. And finally, we have Daniel Müller with us, and he's a member of Paris Bar and holds a PhD in Public International Law of University Paris Nanterre and the Humboldt University Berlin. He has represented the states as consul and advocate on numerous occasions before international courts and tribunals, including the International Court of Justice. He has also represented investors in the investor-state disputes before arbitral tribunals, including in disputes concerning the Energy Charter Treaty. So, as you may know, the ECT is the only multilateral framework regarding the energy sector, and there has been an ongoing argument whether it should be modernized or not, because states started to withdraw it. So we asked for these essential names today to discuss all the things. And actually, I'm gonna start with Mats Andernas, and what I'm gonna ask for him is that what's going on with the ECT? Why there is an ongoing argument regarding the modernization process?
Well, thank you. It's a great pleasure to be here, and of course, a panel chaired by you and with such distinguished experts. And of course, I think one of the things we do share is that we have a multidisciplinary background. We know a bit about international law, we know a bit about the arbitration. Some of you know a lot about all of this, but I know a little bit about a whole range of issues. And just to follow the EU institutional side is a full-time job, which people like us have to fit in with everything else. And then I wrote the Common Market Law Review note on ACMEA, the investor-state dispute settlement agreements under the agreements between EU member states internally in the EU, the ACMEA judgment, and that's of course primarily a question of internal EU law, and you could say some of the modernization is that too. But at the same time, I think it is clear also from some of the cases, some of the awards that the Energy Charter is ripe for modernization. But in the EU, you have a number of particular issues which of course go beyond the ACMEA, the internal, in between EU states investment treaties. EU is, of course, the European Union is, I expect in many ways, now becoming the most sophisticated actor when it comes to investment treaty and investment protection. And it is interesting, of course, just to remember in the back of our heads to have the EU perspective the whole time, that the EU treaty opens up for foreign investment. It guarantees foreign investment in a way I expect no other legal system does. It's part of free movement, and whereas free movement usually closes out non-EU states, so you have to have your special agreements. When it comes to investment and free movement of capital, that under the EU treaty has fewer limitations than free movement when it comes to goods, persons, or other forms of free movement. So that means that the EU is a particular actor with a particular internal legal system which opens up for foreign investment in a way which puts it in a class of its own. And of course now, with all these different legal systems within the EU, it is taking on, partially as a consequence of the treaty provisions, partially as a consequence of political decisions following these up in the EU, a role when it comes to investment protection. And I think that the other feature in the EU, which is interesting, is of course that the EU in its legal system is phasing out protection for fossil fuels. I've been working a bit with state aid, and that was not very effective in the last round, of the crisis and all the state aids that the Commission signed off on. But after that round, I think it will be very clear that they won't allow state aid for anything which is related to fossil fuels, fossil fuel production or distribution. So that's another background. That's very pressing. If you're going to phase out investment protection for fossil fuels or state aid or other forms of preferential treatment for fossil fuels, well, then you see that will be important for the in the Energy Charter Treaty. How are you going to deal with that? And as other speakers they'll talk about investor and investment and all the concepts more generally later. And I'll just add a couple of points now, and it's the particularly interesting new article on regulatory measures. And anybody who's been working with investment protection will find that extremely interesting, to have a provision, a sophisticated provision dealing with regulatory measures in an investment treaty. And I think it is clear that the way that is dealt with in this new article with the headline regulatory measures is a sophisticated approach, and it is more advanced, I would say, not only in the way it recognizes regulatory measures, but also the way it recognizes that regulatory measures are not exempt. They are not exempt. They are subject to a basic test, which means that they may be reviewed, and also an investment treaty tribunal may or arbitrators may review it. Now, this new article then proposed with the headline regulatory measures can build on public international law about general legislation, and the international law doctrine, I expect, can be said to, or you could say this is the international law restatement of general legislation. General legislation does not, or nearly never, constitute specific promises. And it's the three arbitrators, Crawford, Alexandra, and Dupuy, in Blue Sun versus Italy, in paragraph 367, in their award, they say, tribunals have so far declined to sanctify laws as promises. And of course, this is one of the arbitral decisions you find on the web, and it's worthwhile looking up. And then they continue. So this is then in Article 300, paragraph 367. And then they continue then by setting out the authorities. Is mainly 3 arbitral awards they cite. And then use, and then they say the council in the article in paragraph 370, council for the claimants took exception to this. You know, this the general legislation cannot constitute a specific promise, and an investor can't base a legitimate expectation on the provision of law. And then the council for the claimants said, well. The law is the most formal statement on which any investor can base an expectation, you know, more than a express individuals directed towards that investment statement. And then the tribunal continues then, Crawford et al., 371. It's true that informal representations can present difficulties, blah, blah, blah. And they then used the opportunity to tighten that up. You know, tribunals have increasingly insisted on clarity and the appropriate authority to give undertakings before they can be binding. But then they go further down and give a very clear and good justification for their general statement, and it's worth reading. But when you come to the application restatement of the general thesis and the restatement in paragraph 372, they say, in absence of a specific commitment, the state has no obligation to grant subsidies, etc., etc., etc. But if they are lawfully granted subsidies, and if it becomes necessary to modify them, this should be done in a manner which is not disproportionate to the aim of the legislative amendment and should have due regard to the reasonable reliance interest of recipients who may have committed substantial resources on the basis of the earlier regime. And you see that is legitimate expectations and proportionality. It just sounds like a law, doesn't it? It's a restriction. Yes, here there's a restriction, or there's a representation which has established a legitimate expectation. And you then end up by looking at the restriction. Is it proportionate? You know, is it proportionate? And I think the European Commission proposal, you know, with this new article, is a signal to tribunals to take seriously what Crawford et al. Restated in Bluesun. You know, this statement about tribunals have so far declined to sanctify law as promises. And you know, arbitral awards tread a fine balance. Most awards look at whether there's any specific promise representation and whether it gave a justified legitimate expectation that the advice that the investor relied on. And this has been clarified and codified in the Commission proposal. And you also have in Article 10 on the promotion, protection and treatment of investments, further restatement and clarification. And the last point I'm going to make is that the Bluesun Tribunal, you know, Crawford et al., they state that this restatement that they give is customary international law. And then it becomes interesting to look at the cases. You know, Vattenfall may be a borderline case. We can go into the facts and try to apply it. But the contribution by the Commission in this context, I think, is a valuable one. I think it will have an impact on what arbitrators will do. They'll look at this, and I think it'll highlight the work done by the gradual clarification that Crawford et al. Has contributed to. And I think this is also a good opportunity to say that when I now sat down and prepared for this seminar, thank you very much for pushing me through that. I'm very grateful for that, because I was aware of a number of these issues. I tried to follow. I actually probably going to write about it, but just now I had to get it together in a very short period of time for your seminar, and I put it up and hadn't looked at how important James Crawford had been, and I knew him, and those of you who don't know him, he was this Australian who became a professor in Australia, of course, Oxford doctorate, didn't like Oxford that much, went back came to Australia, a professor, distinguished career there, and then he became a very distinguished professor in Cambridge, and then a judge of the International Court of Justice, and he died earlier this year, but he just sat on many of these tribunals as an arbitrator. And I know his mission was this. He believed in investment treaty arbitration, and he thought he was going to make the revisions, adaptations which were necessary for the system to survive. And I think this is an instance of that, public international law influencing what the tribunal did, Crawford et al. in Blouson. And then you see how the Commission has picked this up, and then to some extent, if they've taken out some protection here, which you probably also could say, they've reduced the protection, well, then you get the next issue which comes up, and that is to the extent that, for instance, the Blouson Tribunal has said something is based on general public international law, then that probably will be still law which has to be applied by an arbitral tribunal. And I think it's obvious that this is not an area where all the questions were clarified either by Blouson or by this proposal from the Commission, whether it is adopted or not. But I think the time for these Commission proposals is absolutely ripe, perhaps even over-ripe. And I think the way they build on the tribunal awards and arbitral awards, and the way they nuance it, will still leave open questions which have to be settled if it were to be adopted by tribunals. And that, of course, makes for many more interesting seminars. So many thanks again for inviting us.
Thank you so much. It was really interesting to hear. So I'm going to give the floor to Mr. Mehmet. And my question is that, could you please explain us, how did this need for modernization arise? How did it start?
Well, I was personally involved from the very outset on how a European Energy Charter, 1991 started, then evolved up to now in many ways. First, as a Turkish diplomat involved in this energy diplomacy, then together with Professor Thomas Walde, I was studying at Antennes, that we worked together on producing this blue book, which is the Bible of Energy Charter, I think, at that time. And then I was at IEA, International Energy Agency, working on these issues. Finally, I was the special envoy of Energy Charter until last year, in charge of outreach beyond current membership, Africa, Middle East, China, and other Asia-Pacific nations, as well as the modernization process, which we kicked off in Ashgabat back in 2018. But I think if you look at the chronological order, you see that the real milestone was the withdrawal of Russia from the Energy Charter process back in 2009, almost 12 years ago, saying that Energy Charter was useless in terms of impact on the transit issues arose with the Ukraine, the transit matters. And Russia at that time called for a modernization of Energy Charter. In fact, total replacement of what existed and some other framework put forward. So now what we are discussing is somehow related to this as well, because Energy Charter without Russia was not so relevant, because the whole purpose of creating European Energy Charter at that point was to protect foreign investment vis-a-vis former Soviet Union. First, the non-discrimination, right to expropriate, transparency, resolution of disputes, and other matters that came into force. So where we are right now is quite interesting, because things, as we all agree, are changing so fast in the energy sector and climate change matter. Dynamics have evolved since this treaty has been conceived and put into force. So we have now abundance of supplies, especially in fossil fuels, but also in renewables. And demand is declining not only because of the COVID-19, but other factors also associated with that. Climate change, Green Deal, energy efficiency technologies, hydrogen, fourth generation nuclear. So we have a totally different environment in which the energy sector is moving forward. Therefore, this also calls for modifications in the treaty. And it's not only modification, as we see, it has now become modernization, but the members and parties to the Energy Charter Treaty have different perspectives and interests to satisfy. For example, European Commission is not quite happy with the way things are moving, although it is the primary financier, sponsor of the Energy Charter Treaty. And then we also included now not only European countries, for which the charter was designed for, but we also have now Central Asian republics, from Kazakhstan to Turkmenistan, Uzbekistan. And then we also have China as an observer, which has great interest in what's happening in Energy Charter, because China is not only a recipient of foreign investment, but also a provider of foreign investment in the energy sector all around the world, including in Central Asia and Middle East. And we also have African nations. I was personally involved in bringing Jordan to Energy Charter, also Pakistan somehow, alongside others. Therefore, it has changed in nature significantly. Now, how are you going to satisfy the requirements coming from different quarters? You know, Africans, Middle Easterns, Asia Pacific nations, and European nations, Americans. They all have different interests, divergent interests. Also, Europeans have burned fingers, and Spain and Italy and some other countries have to pay some heavy fines under their contractual obligations of the Energy Charter because of closing down their nuclear power plants, coal power plants. And there is a concern in Europe how this process will continue. Of course, we have now, I think, 6th round of negotiations for the modernization, and it will continue until the next end of the year. We don't know whether this process will be successfully concluded, but I think there is every reason to expect that this process should continue because the whole industry is needing it. Last year, you may remember perhaps that according to IEA figures, there has been about $1.5 trillion of investment in the energy sector. A year before, it was 1.7 trillion. And the bulk of this investment is going to renewables and efficiency and technologies. Whereas I think investment levels have been significantly curbed in the fossil fuels, oil, gas, and natural gas, and coal. And we will also see less and less appetite in energy infrastructure, especially for pipelines, which need to be upgrading, or new pipelines have been proposed. I don't think that there is much future in that. Even I was involved in the Asian Development Bank's project in the Tapi from Turkmenistan, gas coming all the way to Afghanistan and Pakistan and India. And now with the renewables becoming so easy and politically also less controversial, such projects will become redundant. Therefore, I think it's very timely to continue and work towards modernization of Energy Charter. And the outgoing Secretary General, Urban Rusnak, in one of his interviews, a good friend of mine now, he made an interesting comment in one of his interviews. He said, we are aiming to make Energy Charter a supplement to the 2015 Paris Climate Agreement, showing that Energy Charter is also looking for a new identity and new, because if you look around, there are so many energy-related international organizations. IEA, you have the International Energy Forum, ARENA, the International Renewables Energy Agency, then ECT, and World Bank, UN, they all work toward the same goals. So Energy Charter, I think, is unique because of the legal instrument that it has. But as it stands, I think it creates difficulties for investors, for host countries, and it is very important that we have to conclude satisfactorily for all sides the modernization process. That's not an easy task. It requires a lot of effort, a lot of patience, painstaking negotiations as happening. Therefore, I would like to congratulate Arbitration Center for taking up this matter and discussing it among ourselves. And I think there will be need for further reflection, further support to this process. It should not be limited only to member countries and parties involved. I think it has to involve all the stakeholders, including investors, including think tanks, including legal groups like yourself, academics, and whoever is going to lead this process from now onwards. I hope the European Commission will be truly engaged rather than trying to get rid of this process and turn it into acquis communautaire within the European Union. There are lots of issues. So 6 rounds of negotiations, I've observed some of them in person, have not taken us anywhere yet. Pre-investment decision and right to access to infrastructure, so many issues are now under discussion. Let's not expect that this process will be expeditiously concluded. However, if we are all involved in it, hopefully at some point United States as well as the largest provider of fossil fuels right now in natural gas as well as oil and nuclear somehow, Japan, Australia, Singapore. So it has to be a global platform and instrument rather than only involving European nations. I think bringing in Central Asians was needed at that point in order to give new presence to the European Energy Charter process. However, it also complicated the matter somehow because Kazakhstan, Uzbekistan, and Turkmenistan are important players in fossil fuels, but they can also somehow complicate the process within the Energy Charter treaty modernization efforts. So I wish every success and patience to the new Secretary General to manage this complex process. However, as I said, I will strongly advise that this process should not remain only within the frameworks of member governments and other parties coming from outside like China. It has to involve those who are putting money behind it, like the investors. Business, although there is a process, of course, involving business community, but it's more or less a lip service. I think it has to be stronger. And NGOs are very strong. And some of them are very vocal and also obstructive somehow, but we have to take them into account. So we have to provide the link between investor protection rights, host country requirements, and climate change, energy efficiency, new technologies. It's a really difficult task, but it can be done. I'm very optimistic about it. We all have to support this process to see that it will be reached to an optimum conclusion. You cannot satisfy all parties. You have to find the middle ground and reach an optimum solution so that it can serve our purpose. Thank you.
Thank you so much, Mr. Ötçü. As you said, we have an issue that the states are starting the withdrawal, and when it comes to withdrawal, I guess climate change and the states are regulating to protect their environment, and there is investors, so there is this dilemma. That's why I'm gonna give the floor to Ms. Anya so that she can actually talk about the environmental side of modernization. At the same time, as I mentioned, she's one of the climate change councils. You should check her LinkedIn page. And I'm just giving the floor. And before giving the floor, actually, I would like to add something. We are gonna have 10 minutes Q&A session after the speech of our all panelists. So now the floor is on you. Yeah.
Thank you so much. Thank you. I'm also really happy to be here. Thank you for inviting me. I will use my 10 minutes to talk about the ECT modernization in the context of climate change, which Mehmet sort of touched upon, and I will just sort of take a little bit of a broader view, perhaps. And I want to say, like, no offense to the other speakers, but I really do believe that, you know, climate change and the need for clean energy transition is the most important aspect of ECT modernization. And I think all other topics within the modernization process should really be viewed in the context of this, of the clean energy transition. Mehmet sort of alluded to that a little bit. As of course, most of you know, 190 states and the European Union have signed and ratified the Paris Agreement. And all those states have committed to limiting global warming. The Paris Agreement uses this language of highest possible ambition. And that means that the signatories have essentially committed to doing everything in their power to reduce their greenhouse gas emissions. As far as I know, all the ECT member states, except Turkey actually, have ratified the Paris Agreement. And that means that they too have, committed to pursuing very ambitious climate action. And of course, as we all know, energy is a major source of greenhouse gas emissions. So a lot needs to happen in the energy sector in order for, the international community to reach the targets that we've agreed upon. And the IEA, the International Energy Agency, released this report in May this year. Some of you have surely seen it. It was titled Net Zero by 2050, a roadmap for the global energy sector. And in that report, the IEA presents this analysis showing that in order to stand even a chance of meeting the Paris Agreement goals, and perhaps more importantly, to avoid catastrophic climate disaster, we need a historic surge in clean energy investment. And we also need no further investments in new fossil fuel supply projects. And the IEA said no further final investment decisions for unabated coal plants. Again, this is not my opinion I'm stating here, it's analysis of the IEA. So the fact that the world needs to stop investing in fossil fuels may be sort of uncomfortable for some ECT member states, or even maybe some people in the audience, depending on your affiliation, there may be some oil and gas representatives. But even if it's uncomfortable, it's a reality at this point. Many governments and large corporations have already set very ambitious goals to cut carbon emissions by 2030, and most have, committed to becoming completely climate neutral by 2050. So to reach these goals, states and corporations will need to reduce their emissions drastically, and a large part of those reductions will need to come from phasing out fossil fuels. So that's the context, right? It's against that background, that extremely important context, that I think we should view the ECT modernization process. We all agree that the ECT is the most important treaty in the energy sector. And as such, it simply must align with the goals of the Paris Agreement, and it has to support the goals of, or it must support this clean energy transition that we are all facing. So I guess the question is, does the ECT support that transition, and does the modernization process to date support that transition? What do you think? It's a rhetorical question, but you can form your own answer. Different stakeholders have different views on how the ECT, and perhaps specifically the ECT's investment protection provisions, affect the clean energy transition of the member states. Critics of the treaty, including many civil society organizations and some states, and I'm bringing this up here because those organizations aren't necessarily reflected on this panel, but I think it's sort of important to recognize that there is this very critical perspective out there. So these critics say that the ECT hinders the clean energy transition because it protects fossil fuel investments and allow oil and gas investors, for example, to bring arbitration claims against host countries when those states decide to phase out fossil fuels. So we've seen examples of that kind of claims, by Vattenfall against Germany, RWE and Uniper against the Netherlands. So critics say that these arbitrations, or even the threat of such arbitrations, caused a regulatory chill, meaning that the states will be reluctant to regulate for clean energy because they fear expensive arbitration claims, and of course also expensive, potentially very large arbitration awards that they'll need to pay. So last thing, what the critics say, they'll typically say that the efforts to modernize the treaty are doomed to fail, or even if they are successful, they won't go far enough to support adequate climate action. And so they say, the best thing for states to do is to withdraw from the ECT, and so that they can regulate without fear of investor claims. Of course, the reality is much more complicated than that, but that's sort of the nutshell version. On the other hand, of course, there are other observers, proponents of a continued role for the ECT, that instead point out that the treaty is, in its current form, technology neutral. It provides the same protections to renewables as it does to investments in fossil fuels. And, seen from that perspective, the treaty actually supports the clean energy transition because it encourages and protects investments in renewables. And of course, also, as we've seen, it holds, the ECT provides the opportunity for states to be held accountable when they change or even cancel incentive schemes in the renewable sector. This is, of course, what we've seen in all those solar cases against Spain in the past decade. So that point, I mean, that the ECT supports energy transition is also illustrated by the fact that to date, there have actually been more cases about renewables than about fossil fuels. Although I do believe that might change as more and more countries commit to net zero and sort of start regulating to phase out fossil fuels. I think as this happens going forward, we'll probably see a trend of investor cases brought by fossil fuel companies, along the lines of RW and Uniper. I wanted to sort of talk a little bit about how these perspectives on the ECT have informed the modernization process so far. I would say that whether and how to make the ECT more green or climate focused, climate friendly perhaps, has been a big part of the negotiations. Mehmet already talked about this. And he also mentioned, that the most vocal proponent of climate focused reform of the ECT has been the European Union, which of course have made several proposals designed to align the ECT with the EU's own energy transition goals and policy. And I know that the next speaker, David Collins, he'll talk more about the EU proposal, but let me just focus or just mention actually like 3 aspects of the EU proposal that are particularly relevant to what I'm talking about. And so first, the EU has proposed that all fossil fuel investments should be phased out of the ECT's scope of protection by 2040. Second, the EU proposal seeks to address this regulatory chill issue that I talked about before by reaffirming states' right to regulate in the public interest. And third, the EU proposal also includes a new obligation on member states to what they say effectively implement, sorry, the air quotes, but effectively implement the Paris Agreement. And this would be an obligation enforceable by state-to-state arbitration. So the EU has been the most vocal proponent for a greener ECT, but it's certainly not the only one. Support has also come from Luxembourg and actually also from Turkey, Azerbaijan, Georgia, and Switzerland, and surely others that I've missed. And opposition has been expressed by Japan, most notably, and also by other signatories whose economies remain dependent on oil, gas, and coal. So what happens now? I think, again, previous speakers sort of mentioned this, but there are many diverging interests expressed in this modernization process. And I would say that unfortunately, it seems quite unlikely that this EU proposal will get the unanimous support necessary to amend the treaty. And whether a compromise will be reached, is anybody's guess. It remains to be seen. But so the modernization process is progressing extremely slowly, and I, from the outside, it's unclear how much progress is really happening. And meanwhile, this need for global clean energy transition is immediate and urgent. So it's sort of this, like, we really need change fast, and yet it's going so slowly. So I really wanted to end on a hopeful note, although I'm just not sure if hopeful is an adequate reflection of reality at this point. But nonetheless, in the spirit of hope, I wanted to sort of leave you with this thought. I wonder if perhaps there are creative ways in which law practitioners, arbitration counsel and arbitrators can use the current version of the ECT to support energy transition and climate action. The ECT in its current form actually already has some good environmental provisions in it. And arbitrators, actually do have quite a bit of room when it comes to treaty interpretation. So perhaps, the ECT in its current form could be put to better use while we wait for the new version. So just an idea. So before I hand over the microphone, I also wanted to mention that my colleagues and I are currently conducting a review of all of the arbitral awards that have been rendered under the ECT to date. And we hope to release some preliminary results of that study in conjunction with COP26 in Glasgow later this year. So if you are interested to find out more about that study and our findings, follow us on LinkedIn. Thank you.
Thank you, Anya. I'm sure everyone will be interested in reading it, and afterwards I'm gonna read it for sure. And now I'm gonna give the floor to David Collins, but before that, Mats Sandnes needs to leave. So if you have any questions to him, you can reach out to him through LinkedIn or through his mail and ask your questions. And thank you again for attending today. Now I'm just gonna give the floor to David Collins, who was actually one of my professors at the University of London, and at the same time he teach me the definitions of investor and expropriation under the ECT. So today I invited him because I really enjoyed his classes, and I'm sure he is one of the experts of the Energy Charter Treaty. So I'm giving the floor to you now.
Okay, thanks very much, Tutra. This is a really great opportunity, and it's caused me to have a look at the Energy Charter Treaty again, which I hadn't in a while. I want to talk about very briefly the contribution that the European Commission's proposal has made, not so much to energy as a sector, but to investment as an international legal concept. And I would suggest, as an educator, someone that looks at international investment law, the modernization proposals that the EU has put forward for the Energy Charter Treaty really speak to many of the changes that have been underway in international investment law in the past, I would say, 20 years or more. And we also have to think, really conceptualize the EC's proposal as really effectively the EU's model investment treaty, or a model chapter of a free trade agreement covering investment. So very briefly, I want to look at some of the features, the specific nitty-gritty of what's in this proposal, which I think really reflects the modernization, the sort of 21st century approach to international investment protection. First of all, the definition of investment in the proposal expressly now includes indirect investment. And it also appears to include what we in the past have called the Cellini formula, taken from the famous Cellini dispute, which lists what we understand to be the components of an investment. The definition of investor now expressly requires an effective and continuous link with the home state, designed to address that really thorny issue of treaty shopping that so many practitioners and students have grappled with. And that goes on to explain that in EU terms, substantial business activities in the home state. The umbrella clause is gone. And now umbrella, I think 2021 umbrella clauses really are a vestige of the old days, of the past. I don't think now we will potentially ever see umbrella clauses again in modern investment treaties. We've already heard comments about the right to regulate, and I just want to reiterate how important this is. In fact, if anything, this is really the foundational change I think that's happened in investment law in the last 20 years. There's always been this idea that the regime has been biased in favor of investors. It accords rights to investors to do all kinds of things, and it takes away powers from states. The right to regulate really is designed to address that issue. It expressly allows states to engage in measures, regulations, and so on for various public policy initiatives such as the environment and labor and so on. And that's now, in a sense, becoming standardized in investment treaties. You see it, for example, language like this in CETA, the EU-Canada agreement. You see language like it in the CPTPP and so on. We've got an elaboration on what fair and equitable treatment means, and as Tuccia was in my in investment module a few years ago. This is something that students are expected to learn, and it's very complicated. What does it mean? Well, I don't really know what it means. It means lots of things. Well, here we see a much clear delineation of the kinds of things that fair and equitable treatment means. Again, one of the main criticisms of international investment law is that FET had been too broad. Once again, this is reflecting practice that we've seen in other treaties like CETA. So legitimate expectations, denial of justice, manifest arbitrariness. Then we have another clause which the EU also inserted into CETA, which says that the removal of a subsidy does not amount to breach of FET or amount to indirect expropriation. So this is the Mikula case and all those issues being rectified here. The most favored nation provision, which we see in the EU's proposal for the Modernized Energy Charter Treaty, expressly includes investor-state dispute settlement found in other treaties. Thank you very much, because that has been such a debate. It's been so much controversy. Does MFN include ISDS or not? Here, the EU has solved all of the problems by saying, no, it doesn't. So that I think that's going to solve major headaches. Whether or not you agree with that, it's solved major headaches in terms of interpretation. Have a clearer definition of expropriation with an annex. It's maybe not as clear as it could be. It doesn't specifically list the kind of things that will constitute an expropriation, but we see much more developed language, actions which deprive the investor of fundamental attributes of property. So I think that's going to be easier to interpret. From my recollection, I think the CPTPP gives a little bit more even than this does. There's also something that I've wanted for years, and I can't help but think that maybe somebody read one of my articles who inserted this into the proposal. In the prohibition on restrictions of transfer, capital transfer, which is standard for investment treaties, there is now an explicit reference to IMF rules. And what I'm talking about is it says that signatory parties are allowed to restrict capital transfers if there are serious balance of payment difficulties, and this is in line with IMF obligations. Now, I had been someone that always said you could read that into the treaties previously, because if the IMF required that, and now we're seeing that expressly made. Once again, thank you to the Commission for clarifying that. And interesting comments we've had from all of our speakers about the environment and climate change. I won't say any more about that, except one point. There's explicit references to environmental impact assessments. in order to achieve sustainable development. And there's an elaborate sustainable development chapter. This is very modern, very progressive, more so than any other investment chapter that I've seen. General exceptions, which standard for investment treaties, they're now more elaborate. They're based upon the GATS, the General Agreement on Trade and Services of the WTO, the general exceptions from that agreement. And we see express reference to measures regarding public security, public order, public morals, privacy. All these kinds of measures may be permitted and yet not face the state would not face consequences under the treaty from claims by investors. So once again, I think you're seeing a real enlargement of the public policy regulatory sovereignty, as it were. So that's addressing these chilling effect arguments. Changes to dispute settlement. I think perhaps the next speaker is going to talk about this, or if not, it's fine anyway. I don't want to spend a lot of time on it. I could go on and on about this. There is investor-state dispute settlement in here, and it talks about the parties to consider developing a multilateral investment court, which we know the EU, that's one of the EU's big projects. So it's encouraging parties to consider that. There's a provision eliminating frivolous claims. There's a provision that sets out that the costs of arbitration will be borne by the loser as a default, also inspired by CETA. The UNCITRAL transparency rules will apply as a default, very modern, very standard now and progressive BITs. Permission for amicus curiae participation, same thing. Security for costs, and also disclosure of third-party funding. Interestingly, and you have an entire seminar about this, there's no punitive damages. Fine, I think that's pretty standard, but my reading of the language in there suggests that there's no moral damages allowed either. And there's a phrase, damages not greater than loss suffered. So I think that's an interesting development as well, because there's an increasing number of claims in investor-state dispute settlement which have recognized moral damages. And then finally, my last point, because that's my 10 minutes, I think Annex 10 specifies that no claims related to public debt may be submitted. This has been another big controversy. There was the Postova case, which I think was against Greece, where these issues were dealt with. And this proposal is clarifying that those claims will not be permitted. So once again, I would say, just to conclude, the European Commission's proposal for the modernization of the Energy Charter Treaty, in as much as they may affect how the Energy Charter Treaty itself develops, I think they're a massive statement about where international investment law as a discipline has gone, how far it's come in the last 20 years or so. And this is really sort of cutting edge of what you would expect to see in a modern investment treaty anywhere in the world. So I'll stop there. Thank you.
Thank you so much clarifying the definitions. And now I'm going to give the floor to Ms. Danielle Miller, and I'm going to ask him the question of what is the problem of the dispute resolution under the ECT, and how can it be modernized?
Well, thank you very much. I think I can very quickly answer to your question as you have just asked it. I think there is no real problem with the dispute resolution system as it exists now in the ECT. I mean, it is a pretty standard dispute resolution system, based on 3 months of amicable settlement, tentatives. And if this does not reach to a solution, then the investor can choose between multiple options, including municipal courts, by the way, which is of course not very often. I mean, you don't see those very often because it's not so much in the public domain, but it's an option which is there. And by the way, there's also an option for conciliation, which is quite often overlooked. So conciliation is mentioned in the ECT Article 26.3, a little bit between the lines, but the ECT Secretariat has clearly affirmed recently in a paper on conciliation that that's an option which is there and which probably should be used much more, not only in the amicable settlement period of time of 3 months, but also once the parties are more on the hot side of the dispute. And otherwise, I mean, it's standard arbitration under Explicit rules or before the SCC or under Uncitral rules, which gives actually quite a big variety of arbitration institutions like yours, or like others in Paris, ICC, etc. And another good point to see that the dispute resolution mechanism works quite well is actually if you look at the figures. So according to the numbers which are available on the website of the Secretariat, you have had 136 cases under the ECT, which is quite a lot for an individual, investment instrument. 50 of those cases are still pending. 50 cases are still pending because I think they are not absolutely up to date. And a little more than 30 awards which were rendered under the ECT have concluded that the ECT has been breached by a contracting party. So that's around 25%, doesn't really sound huge, right? At the end of the day, you can really say there's certainly not a bias from those tribunals vis-a-vis investors, just giving investors all the time damages. And there's also certainly not a bias concerning renewables, as Anja has already said. I mean, most of those cases concern renewable energy projects and investments. It's around 70 or so, because of the Spanish cases, of course, Italy, Czech Republic. But if you take out the UCAS saga cases, which are in terms of damages a little bit, by the side, I think much more damages have been awarded in renewable energy cases than in more conventional energy and investment cases. So you see, actually, it works pretty well. And I think here's a link between the dispute settlement mechanism and the modifications proposed to other aspects of investment protection, the substantive protections. The problem is clearly the system of investment protection as such, arbitration, not very, at least you might have the impression that it's not very coherent. Tribunals actually decide this way or the other way on the same instrument. And there's no real stream of case law developing. At least that seems to be the impression, mostly by states, right? Another factor is, of course, certainly the costs of those things. Some states face important costs in order to address those issues. Other states have, managed to make this actually more streamlined, as Spain, which is doing this in-house now all the time, and which have developed perfect skills to address those cases. So there is actually a real question whether you need to reform this system in the ECT or the system as such. So David has already spoken about some specific proposals made by the Commission concerning the modification or additions in the ECT concerning dispute settlement. You might be in favor of it or not. I think it's a little bit, overkill because furious claims, for instance, has already been included and addressed by several institutions like Exit, Article 41.5, which works quite well. Same thing for transparency. It's of course good to have it there, but that's something which is around. Security for costs, I do think that the article doesn't add actually anything because it repeats only what is developed in case law already. Valuation of damages, I'm also a little bit more reluctant than David is. I think it's just a restatement what of international law actually says. Loss suffered actually includes for me also moral damage. But you see, it actually creates new issues of interpretation, these articles. And the biggest proposal is certainly the multilateral investment court proposal, which needs to be agreed outside the ECT. So that's not specific to the ECT, but which might actually bring a little bit of a revolution to the entire system. The big elephant, I just want to mention this, we have already spoken about this at the very beginning. The big elephant in the room is certainly ACMEA. And the question whether the system as it exists or the system as it might be established after renegotiation is in conformity with EU law. So there are several opinions in the room. The Commission is clearly advocating for saying, oh, that's not in conformity with the EU law, and we can't have intra-EU investment cases under the ECT. all arbitral tribunals which had to address this question have decided the other way around. And now it's, of course, for the European Court, for the Court of Justice of the European Union to take a stance on this. There are 3 cases or so, and pending quite recently, the Advocate General Spunar from Poland has actually opined that ECT does not include intra-EU investments, though that's actually quite in the air, and a real modification of the treaty can only take place once this issue has been resolved. And the treaty might actually include some provisions, which were, by the way, proposed at the very beginning in the 1990s, in order to, when the ECT has been first negotiated, but which have not been included in this text. So there might have been some adaptations to the ECT language in order to address this intra-EU issue. And that's not only an intra-EU problem, because it might also affect the way how the investors from third countries, third contracting parties, can rely on EU law in arbitrations or dispute settlement proposals under the ECT. Thanks a lot.
Thank you so much. Now the Q&A session begins, and before receiving our questions, I would like to actually ask a question to our panelists. Since there is a sunset clause, which means that foreign investors can continue to use the dispute settlement mechanism under the ECT after withdrawing the treaty. So do you think that just withdrawing the treaty is the solution? And why do you think that the countries are withdrawing it, even though there is a clause like that? So they know that they're going to be sued, but still they are just withdrawing it. So which does it really shows that we need a modernization?
Should I go first?
Yeah, sure.
So I think that's probably a general problem, also how states try to manage this kind of issues and their policies in order, especially in the energy sector. They quite often came a little bit after everything has happened, right? So withdrawing once you have modified your system in order to address certain specific issues, like Spain did, or like Italy did, by the way, is certainly not a good deal. I mean, they need to be aware of the obligations they have actually entered into when they change their policies. Or if they see that there might be a problem, well, then get out of the ECT or your bilateral investment treaty beforehand. During the renegotiation process, the sunset clause might not be a big deal, because you might actually just, if the states just change the sunset clause, they will just change it. It's a difficult issue, but I consider that, states have put up in a sunset clause in a treaty, while they can also just decide, well, it's not there anymore. Like the European Union member states have done in the termination treaty provision. And I think this might actually work. Might get a little bit of disputes around this, but at the end of the day, I think this might settle in this way.
I'll just add to that I think, it's really hard to know why states choose to withdraw, even though there is a sunset clause. Like, I'd have to believe that in each case, there are not that many states that have withdrawn, but we don't know what regulations or what changes in their investment policies or that they are looking at prospectively. So I would believe that, I'm sure there's a very elaborate cost-benefit analysis when it comes to weighing, the risk of arbitration claims during those 20 years and the perceived benefits of a withdrawal from the treaty. There's also, I want to say, among critics of the ECT in its current form, there's some people who really propose that there should be like a mass withdrawal combined with then an agreement among the withdrawing states that they will not allow the application of that sunset clause. So they're trying to get out of it.
Yeah. Thank you so much. And I'm waiting for the questions. If you have any questions, you can ask from the Q&A session. Also, we have the chat, so you can ask your questions through there. Till then, I would like to make a little introduction regarding Turkey Arbitration Week. As you may know, we are organizing the first Turkey Arbitration Week between the 1st and 5th of November of 2021. And what we are planning to do is bringing all the academicians, lawyers, and companies together. So if you would like to join, you can check our website. And let me see whether we have any questions. So I'm just gonna wait for a minute to see. Yes, till then I'm gonna give the floor to Ms. Anya.
I'll ask a question, or maybe just Daniel, you mentioned transparency, and you sort of said well, transparency is already around, or something like that. And I just wanted to see if you could say a little bit more about that, because I mean, from my view, I worked at the SEC in Stockholm for 5 years, and there's certainly, I mean, it's one of the few institutions that do administer ECT cases, and there is as much confidentiality surrounding the ECT arbitrations as there is around the commercial arbitrations. So there's zero transparency from the institution side. Perhaps, the parties agreed to something different. And I think that transparency actually have a really quite a big role to play when it comes to dispelling some of the criticisms or myths, some might say, around sort of the nature of investor-state arbitration.
Right. So, I mean, what is now in the proposal from the Commission side is actually not much more than just a reference to the UNCITRAL rules of transparency, which of course, I mean, it adds something because it would be the standard procedure applicable under the ECT. But if you do those cases in the real world, actually you might be surprised, but quite often it's the states which are against transparency and which, you draw a bracket a little bit, don't want to have everything published on the website or this depository or whatever it is. I mean, it might depend also the kind of investment where transparency issues are maybe a little bit tricky to enforce entirely, just because there's a lot of confidential stuff or so. So, I mean, transparency is certainly one of the big issues in the reform of the system as such, right? And it will come through this rather than through a specific article just in the new ECT on dispute settlement, I think.
Thank you so much. We have a question, and before passing that, yes, the recording will be accessible. We are going to share it through our YouTube channel, and you can follow it from there. You can watch it. I guess tomorrow morning we're going to edit. And we have a question from Burak Bitkin. He's asking, as by today, there are 136 corporate claims on ECT, while just 19 cases were registered during the first 10 years of the agreement. The number of claims has exploded in recent years, especially with Spain, with more than 53 claims. Why do you think that there is a huge concentration on Italy and Spain? Also, do you think that the case concentration on these two countries become the trigger on the rethinking ECT? So, yeah.
I go very quickly on that. I had spotted that the ECT was actually not a lot used in the first years. It's quite a normal thing normally. I mean, a treaty needs to be there for some time in order to be invoked for the first time. ECT was, of course, quite prominent with the UCAS cases. But then there was an explosion in the last 10 years. I mean, almost 80% of the cases which were introduced come from the last 10 years. you can't really say that there's a concentration on Spain because it's Spain or a concentration on Italy because it's Italy. I think it's just because of the measures which Spain has taken. Of course, there were a lot of investors which actually tried to use this possibility in order to have some kind of remedy. And we are speaking about, energy investments which have this particularity that it's normally a huge upfront investment and engagement of capital, specifically in the renewable energy sector. You have to build your solar panels or whatever, you put them there, and then these things need to stay there for 25 years in order to get your return. So if the state changes this, of course, it just changes the entire economic system which was envisaged by the investor. So these investments are quite sensitive to these kind of regulatory measures as enacted by Spain. And I mean, if you look at the Spain cases, a lot of cases actually have concluded that there has been a breach of the ECT by Spain. Now, the problem is maybe a little bit more on the EU side again, because as you might have seen, the European Commission has recently started state aid investigations into the potential payment of one of the awards by Spain to the investor. But I don't think that this was the specific trigger to modify the ECT, because the renewable energy problem and the modification of the energy system to a more sustainable system has been around independently of those cases, and those cases are renewable cases. But of course, all this kind of very detailed reformulations of standards, definitions, this is certainly a reaction to the great number of cases where states might be a little bit disappointed about the outcome, right? That's why, and if you look at the proposal from the European Commission, I mean, David has spoken a lot about this, but quite often the provisions just say, for sake of clarity, or for greater clarity, or for greater certainty. So that's not the legal drafting you would normally try to include into this kind of international treaty, right? So I think the great cases are certainly a trigger. I don't think that specifically the Spain and the Italy cases are the trigger.
Thank you so much. We have 2 more questions, and afterwards we need to complete our webinar. But if you have further questions to our panelists, I'm sure you can reach out them through their LinkedIn account or through their mail. So we have 2 questions. One of them is that, what about budgetary limitations? How could ECT finance its activities without quite big country donations? Who would like to answer it?
I can address that. Sorry, was the question, how will the ECT finance its activities if some contributors withdrew? I didn't really hear. Yeah?
Yeah, without big country donations, they're asking.
Well, I mean, I think the ECT secretariat could just shrink in size, but if the question is, the ECT, perhaps the person who asked the question thinks more about the arbitrations, like the cost of the arbitrations. But just to clarify, if that is indeed the question, then those are of course covered by the parties to the arbitration. Those don't come out of the ECT budget. So I don't know if that addresses the question, but.
Also, another question is from Dr. Cenk Pala. He's asking, ECT should work ECT signatory countries arbitration center similar to EDAC as substitution of industry advisory panels. What is your opinion on this?
Well, so if this means that the ECT, I mean, investors and states should use more of the arbitration centers which are around rather than ICSID or so for the resolution of disputes, I think I couldn't agree anymore. A problem is certainly costs in arbitration. So ICSID is quite often used because of the other benefits ICSID is actually giving, and specifically in enforcement and so. But it is actually quite an expensive endeavor. to go to an exit case for the investor and for the state, other arbitration centers are less expensive or are more bound to, the sums or the damages in dispute, like the SCC is working or the ICC is working on this basis too. So this might be a more interesting alternative to exit. And I think actually other arbitration centers might play a role there too, not only in dispute resolutions through arbitration, but also in mediation, conciliation, and issues like this. I agree.
Thank you so much. I guess today we outlined all the important points of modernization of the ECT. I would like to thank all our participants to join us and listen us. And also, I would like to say thank you to our panelists. It was a pleasure to meet you today and listen all of this from you. I think it was really essential to talk about Energy Charter Treaty. Just it's the only multilateral investment treaty regarding energy sector, so it should be modernized. And thank you again. It was an honor to have you today. See you. Bye.